All right. So I think we're live again. Hopefully we're working here. So good morning, everyone.
Good morning.
It's Thursday morning, and it's time for our little Google Hangout presentation, and we're glad to be back here on this somewhat rainy day. But we're here to talk about workplace rights, as always, employment law, and everything you need to know if you're working, having a job, lost your job. Maybe you're out there, having something happen to you, and you're worried whether your boss can do this. We're here to answer those types of questions here. I'm Lior Samfiru of Samfiru to Market LLP. With me, my colleague Lumi Pungea. And the topic for today is an interesting one. It's one that comes up quite often, and one that a lot of employers and employees struggle with, and for good reason, because there's a lot of gray areas in there. But we're going to try to simplify it as much as possible. The topic is medical documentation, medical information. What an employer can ask for if an employee has to be off sick from work, what an employee has to give the employer, and what happens if what the employer provides and what the employer wants don't coincide. So we're going to talk a bit about medical leaves of absence. We're going to talk about the documents that corroborate a medical leave of absence. And then we're going to talk specifically about what information an employer is allowed to get from the employee, and of course what an employer can do if the medical information it gets is not adequate. We'll talk about it from the perspective of the employer and the employee. So I think it's a very important topic, and it's one that we certainly deal with every day, both with our employer and employee practice. Now, medical leave of absence. It is common. Any employer will tell you that they have employees that have to be off work sick for medical reasons. And a lot of questions arise there. So let me start with some general statements. Generally speaking, an employee can be off work for as long as needed, as long as an employer, as long as a doctor corroborates their absence, as long as the doctor says, this employee, my patient, has to be off work. So it's not up to the employer to decide whether the employee is going to get time off work. It's up to the employee and the employee's doctor. Once an employee's doctor says you have to be off work, then that's what the employer has to do, is has to allow the employee to take time off work. Now, the length of the absence, really, ultimately, there's no limit on it. It could be up until the employee is clear to return to work. Sometimes that's a day, sometimes that could be a month, sometimes that could be a year or more. So there's no time limit on that, and the employee doesn't lose his or her job just because they cannot work as long as that absence is corroborated by medical information. So it is that doctor's note, that doctor's letter that starts the process, that allows the employee to take time off work. And so the employee doesn't decide I can't work. It's the doctor that makes that decision. Sometimes an employee may have a disability plan through work they can apply for that may give them compensation while they're off work. Some employees do not have that. That doesn't change the analysis, in that you can be off work on an unpaid leave of absence, even if you don't have a disability plan. In that situation, you may apply to the government for employment insurance that may pay you for a few months while you're off. So whether you have a disability plan or you don't have a disability plan, ultimately does not change the analysis. So with that said, once we've established that parameter that you can be off work as long as you have a medical note, we need to discuss and consider what that medical note should say, or what information an employer should be getting or is allowed to get if you need to be off work. So I'm going to turn it over to Lumi to talk to us a bit about what information an employer is allowed to ask for an employee that's off work.
So I will start by saying that the very common short infrequent absences in general don't require medical notes, or if those are necessary, then only minimal medical information is required. And in many workplaces, employers don't even request medical evidence if the employee is away for only a day or two, and if it's not a common occurrence. But if the employer insists, then a medical note obviously is in order. And what I guess the basic rule is that even the even the flimsiest medical note scribbled on just a little piece of paper counts and should be taken into account by the employer. And so we'll discuss later what options the employer has if they're not satisfied with, I guess, the medical information conveyed on that minimal medical note. But in general, as long as that medical note conveys the fact that the absence is due to medical reasons, and as long as that medical note or the doctor puts in with approximation the estimated return to work, that medical note should be accepted by the employer, and again, if not second guessed. And the other thing that is worth mentioning here is that employers, although the tendency is to ask or request as much information as possible, the employer is only entitled, again, in general terms, to have the prognosis, to have access to the prognosis regarding the employee's medical status, and not the diagnosis. And so it doesn't matter whether the employee has a bad back or a mental illness. What matters is that legitimate medical reasons, I guess supported by a doctor, prevent him or her from attending at work, and there's an estimated return to work date in that information conveyed by the doctor. So the employer is entitled to know when the employee is expected to return to work, or if there's no estimated date for return, when the reassessment, when the employee will be reassessed by the doctor. The employer is also entitled to information that allows it to accommodate the employee, whether accommodation means allowing short medical leave of absence, or I guess setting up the employee with an ergonomic seat. So that's just very basic accommodation. Or if the accommodation is more complex and it requires, I guess, finding another role for the employee, again, the employer is entitled to request and receive that information from the employee and his or her doctor. It should be, I guess, the right of the employer to run its business and manage its employees' absences should be balanced against the employee's right to privacy, and so that is really paramount. Like, employees have a right to privacy regarding medical information, and so, again, going back to what I said earlier about the employer having access to being entitled to the prognosis, but not the diagnosis. There are many instances, and we're seeing this in our practice all the time, where employers overstep their entitlements. And so, Lior, do you want to chat about that?
Yeah, and this is important because, even though we talked, Lumi just spoke about what an employer is allowed to get and what not. That should be straightforward. Oftentimes in real life, it doesn't work that way. Remember that the rule, as Lumi said, that an employer is allowed to know prognosis. So how long you're going to be off, when are you going to be back to work, what the limitations are, not diagnosis, not whether you have a bad back, whether you're suffering from cancer or it's depression. So with that in mind, employers may often try to get additional information. The employers may often try to demand more information and maybe penalize employees for not providing that information. So number one, if an employer is asking for medical information that it is not entitled to have, as we've just described it, certainly an employee cannot, should not provide that information. There's privacy reasons, and frankly, to put it bluntly, it's none of the employer's business. So that information should not be provided as long as your doctor was clear that you have a medical condition, that you can't do work for medical reasons. That's it. If the employer then steps it up, and now the employer is making additional demands or threats, if you don't provide this to us, we're going to let you go. Well, an employer cannot let you go because the employer wants information that it's not owed. An employer cannot consider you to have abandoned your job or quit just because the employer is asking for information that it shouldn't have. So what happens if the employer does do these things? Well, number one, that would be a wrongful dismissal. You cannot let someone go for cause because you don't want to give them time off work, okay? Let's make that very clear. That's a wrongful dismissal right there. It's illegal. But it goes beyond that. It could also be a human rights matter. If you're refusing to allow someone to take time off work or refusing to provide accommodation, that's a human rights issue. Our human rights legislation is very, very clear. Someone suffering from a medical condition, from a disability, the employer has certain obligations. One of those obligations is to tolerate, if you will, an absence. So if the employer refuses to, quote unquote, tolerate that absence, that is a human rights violation, and that employer is ultimately going to be liable for compensation and damages. So my rule of thumb is very simple. You don't mess with someone on a disability leave. You just don't. You don't penalize them. You don't make their life more difficult. You don't make unreasonable demands. And if you do, there's legal consequences to that, and there's legal recourse that's available to the employee. So I want everyone to remember that you're protected. If you're on a medical leave of absence, as long as you've corroborated that absence with the doctor's note, so you're not just off on your own, you were there because a doctor says and has said, and you provided that to the employer, that you can't be off work, that's it, it's done. Now, you should continue to keep your employer updated, but if, of course, you're let go because of that, there's consequences. The other thing to remember is if you are let go while you're on a medical leave of absence, that may mean you get more compensation, more severance than you would otherwise, simply because you're not physically able, presumably, to look for work. So it's going to take you longer to find another job if you're not well than it would if you were perfectly healthy. So the same rules that apply to severance may actually be enhanced when it comes to disability leave and letting someone go while they're on leave. So now, that said, there could be situations where the termination itself has nothing to do with the fact that you're on a leave or with the medical information provided. Maybe the whole department has shut down and your employer decides to let everyone go. In that case, it's presumably no longer a human rights matter, but you're still entitled to full severance, presumably enhanced severance, because you still are not well and not able to look for work. So what happens if you're on a medical leave of absence? Well, you stay on the medical leave of absence until you're cleared to return. Once you have that clearance, once the doctor says, yes, you've been cleared to return to work, you need to advise your employer of this, provide them with that note clearing you to return to work, and at that time also advise the employer whether you can return to work on a regular basis as you had before, or whether you need some help, some modified duties, some modified hours, whether you need some accommodation. It's quite possible and likely that your return to work will be gradual, that you can't necessarily go back to work on day one and do everything you did before you went on a medical leave. Initially, you may need to do some other duties, some other responsibilities, and work your way up towards your full-time job that you had before. That's absolutely fine. All you have to do is provide that information to the employer. If the employer refuses to meet what the doctor says, meet that accommodation, that's, again, a human rights matter. An employer has to accommodate. So if an employer says, well, you can only come back to work as long as you're going to do everything you were doing before. We're not going to accommodate you. We're not going to find another role. We're not going to give you other hours. Again, human rights issue. The law makes it very clear. There's a strict duty to accommodate. Even if it's difficult, an employer has to accommodate. Even if it's not easy, even if it costs some money, the employer still has to accommodate. Now, there is a point beyond which accommodation may be too much. If it is going to be extremely difficult and it's going to completely change the employer's operation to provide that accommodation, the employer may not have to go that far. But otherwise, the employer does have to provide that accommodation. And we see every day employers not willing to go to the point of accommodation, and they put a line in the sand and says, either you come back to work doing what you did before, or you don't come back to work at all. So again, if your doctor's telling you and you've communicated to the employer that you have accommodation needs, that you can't come back to work necessarily right away the way you were before, then you have to be accommodated. and it's not up to the employer to decide whether they want to do that or not. So those are some very important tips and ideas from mostly from the perspective of the employee as to what you have to provide your employer and what happens if your employer is being unreasonable. So remember that there is legal recourse, but we can't forget the employer side of the equation. Oftentimes employers want to do right by their employees, but they also have a business to run and they need to be fair to their business. And they get a flimsy doctor's note, as Lumi had described, written on a legal pad and chicken scratch, and says employee can't work. Well, what do you do in that situation? How do you get more medical information that's required? To that, I'm going to let Lumi speak to.
I will start by saying that employers most importantly should be very tactful and diplomatic in those instances, and use common sense and try to be reasonable. Employers should not be cynical about it and assume that employees, just by virtue of being absent, are malingering or taking advantage of their right to take time off in the event of medical problems. So again, employers, be reasonable, be tactful, and approach the situation with an open mind. If you need additional information from the doctor, from the employee's doctor, first and foremost, make sure you have the employee's consent to approach the doctor. It's not a good idea to call the doctor, write a letter, and even better, prepare a checklist with the employee's, like a breakdown of the employee's duties, very, very specific with a lot of particulars and details, and ask the doctor to advise as to whether the employee is able to do each of those duties. And so again, with the employee's consent, send this information or the questionnaire, I guess, the checklist to the doctor, and ask him or her to comment on it and fill out the form. Make it easy for the doctor to again convey sometimes complex medical information in a way that you can interpret and work with. And so I will say that in very, very limited and exceptional circumstances, employers, if they're not satisfied with the medical information they're getting from the employee or their doctor, employers have the option to hire a doctor or propose to the employee to be seen by a doctor of their own choosing, basically a doctor hired by the employer. That's very rare. The employer can request what we call an independent medical examination, but the employee is not obligated to comply with it. And so I will mention it because a lot of employers try to use this recourse, but it's reserved for very, very specific and exceptional circumstances, such as when there's conflicting opinions from two specialists, for example. I will say that throughout this process, the employee has an obligation to cooperate with his employer. And so that means communicating with the employer, making reasonable efforts to set up appointments and follow up with his or her doctor. And an employee, simply because he or she is sick, cannot ignore the employer's request for additional medical information. And so the risk to the employee is that if he or she is not cooperative, the employer has the right to treat the employment as abandoned. And so very serious consequences flow from that. And so again, employees should make their best efforts to to cooperate. And if by virtue of being sick, they are not able to keep up with appointments, for example, or I guess communicate on a steady basis with their employer, then they should seek legal advice and call us, and we'll advise. There are instances where prolonged medical absences, or instances where the employee's return to work is unlikely in the future, and so that gives the employer the option to call the contract of employment frustrated. It's a very technical term, and it applies to very limited circumstances. For example, someone has cancer and the prognosis is very negative. In that case, the employer has the option to call the employment contract frustrated. The employer still has the obligation to pay certain entitlements, termination entitlements to the employee, but I guess it brings closure. It brings closure to the relationship, and the employer can move on and hire someone else, organize the business and administer the business without that employee still on the payroll. It's also important to know that even the employment seniority and service continues to accumulate even during long medical leaves of absence. So just because you've been off on a long-term disability leave, for example, doesn't mean that you're unless the employer took steps to end that relationship, you're still, even if you're an inactive employee, you're still an employee. So those years of service continue to accumulate.
Yeah, and just elaborate quickly on this concept of frustration of contract, because I think it's important. So frustration of contract is a situation where the employee is absent for so long and it's not likely to return, that the employer can say, you know what, this employment relationship has just ended naturally. It's not your fault, it's not our fault, something's intervened, this medical condition. But you need those two conditions. Number one, you need a lengthy absence. Usually we're talking about a couple of years or more. And you need, beyond the lengthy absence, you need there to be medical information that the employee is not likely to come back to work. So if the employee is being off for 2 years, but the doctors are saying that they may still come back to work, there's no frustration of contract. You can't end the relationship that way. And in many situations that we've seen, employers pull the trigger on a frustration of contract way before they should. So remember that, lengthy absence and no likelihood of return to work. Now, before we end, I want to mention one thing very briefly that I think ties into this issue of medical leaves and medical documentation. As I mentioned right at the beginning of the presentation, a lot of employers may have disability plans, long-term, short-term disabilities. Employees may apply for that while they're off work in order to get compensation. Unfortunately, these are administered by an insurance company. And again, not to pick on insurance companies, but the reality is that insurance companies are in the business of trying to get people off insurance. That's what they're there to do. So we have so many people that we worked with over the years, when they've been sick, they've applied for short-term or long-term disability, and they've been denied. Or maybe they've been approved and then cut off shortly thereafter, even though they have a doctor that says, no, you can't work still. The insurance company may disagree. So that's very problematic. If you're now off work, you're sick, you're trying to get better, and your insurance company, the one you've been paying premiums for all these years, now doesn't want to cover you for the very thing they should be covering you for. Well, it's a numbers game. I'm going to be very blunt here. The insurance company counts on the fact that if there's going to be 10 people that we cut off or deny disability benefits, the majority of them, 8 of them, 9 of them are going to accept it and not do anything about it. And even if for the 1 or 2 people that challenge us on this, we end up paying, that's still good odds for us. And that's what happens. That's how that system works. So we spend a lot of times with our clients that have been denied disability, getting them that disability, giving the insurance company the proverbial kick in the pants, so that either they reinstate benefits if they've been cut off, they approve benefits, or get them an additional compensation amount. So if you're in that situation, if you've been applying for disability and you've been cut off, there's hope in most of these cases. As long as the doctor is willing to support your absence, we can resolve the issue with the insurance company, and it's not even overly difficult. So there is hope. There is something you can do about it. We deal with that all the time. If you're in that situation, or someone you know is in that situation, they've been denied benefits by an insurance company, that's very important that they give us a call. Oftentimes, an employer may say, wait a second, we understand that the insurance company has denied you. That means you should be better for work, so you have to come back to work next week, and if you don't, we'll consider you to have resigned. All the meantime, you still can't work. You have a doctor saying you can't work. Now the insurance company is not paying you, and your employer is threatening to fire you. So that could be a difficult situation. But again, we deal with that all the time. We know how to resolve these issues. And I hope that we gave you some things to consider during today's presentation in terms of your legal rights and entitlements as both an employee and an employer. Now, you can always reach out to us with any questions. Check out our website at stlawyers.ca. You can email us at help@employmenthour.com. By the way, Employment Hour is a radio show that we host on AM 640. Check out the website for times. And we will be back here in 2 weeks to talk about more interesting employment law issues. It's close to 8:30. Thank you very much for joining us this morning, and we'll talk to you soon.
Bye for now.